Wherever it is that you are, it is a beautiful, kind of cold-ish Friday morning, and I am so glad that we are here this morning. So today I want us to go into succession planning. Those subjects that we really don't pay much attention to. And the reality is, things like prolonged family feuds are not, strange in Kenya. We have families that have gone into fights for years in situations where they could have easily solved succession issues quite easily and expedited on a process without going into fights. But a lot of times we find people going into feuds, and the reality is when a loved one passes on, it's an emotive time and a time of a lot of stress, and then you have to deal with complex matters such as succession and transfer of assets and all of that, and engage with a legal system that is so complex for a lot of us. And so I was like, what, it's enough is enough. We need to find a solution to this situation. I remember hearing somebody tell me that in the cases that go to court around transfer of wealth in families when there's been a decease of a death of a loved one, 10% of those cases that get to court have wills. Only 10% of Kenyans of African descent have wills. Like, it's shocking. So the question is, why don't we have plans for when we're not going to be here? Because we want to protect our children and want to ensure that they have a safe and secure future. We want to be able to be good stewards of the resources that have been put in our hands. So what do we need to do to be able to do that? So I have with me a fantastic lawyer. She's a friend, and her name is Leah Kiguatha, and Leah Kiguatha is a passionate family law expert. She actually, allow me to just read her profile. She's an advocate of the High Court of Kenya, and so we're in safe hands. She has about 17 years experience and expertise in domestic and international aspects of child and family law. She's also an expert and enjoys real estate and conveyancing law. So we are in safe hands, and I am so looking forward to be able to ask her I have so many questions. And by the way, guys, we are live. Remember, we are live on Facebook and on YouTube, so please ask your questions as we go so that we can handle them. I mean, when will you have a lawyer to sit with to ask these difficult questions? So ask them, keep them coming as I continue asking mine. Good morning and welcome.
Thank you, Rina, for having me.
It's such a pleasure to have you. And I'm so thrilled that you've made the time to come through and have this conversation with me. So before we get into law and all of that, I just want to ask you to share a little bit about who you are and what is it about family law that you're so passionate about?
Okay. I grew up in a family of 4 girls. I grew up with my mom on the outskirts of Nairobi. And so in a family so we were 5 girls. Our cat was also female. So many conversations, rapid, finishing each other's sentences.
Yeah.
And I'm married. I have a little girl who's 10. I tell her God knew that one day my sisters would live far away from me. So he gave me a little sister to replace my 3 vivacious sisters who are now, have their own families. And I have a little boy as well. And so that's basically Leah. I guess I define myself around family. Yeah.
It's it's okay. I think in professional circles, they're always like, why are you telling us about your family? We don't care. But it's a big part of who you are.
Yeah, it is.
Yeah.
It is, yeah.
And so tell me, why family law?
Because family is the foundation of society. Really, when we say that and we say it as if it's really cliche, it's in the laws, it's in the international laws, it's in the constitution. And so we say it in a very cliche, sort of family is the foundation of society. But family is the foundation of society. If things are not working in your family, you'll not build the economy.
That's true.
If things are not working in the family setup, everything else will collapse. So it's very important that we put our families front and center, however you define them, because everybody has a family or wants a family or comes from a family. So it's very, very close to each one of us. So we need to sort of have issues in that space sorted out to be able to now get out and handle things at the societal level, at the national level, at the global level. So family is very important.
So true. I mean, if it's not working in the family, you can't thrive.
Yes, exactly.
You can't.
Yeah. If there are unsettled issues in your family space, you won't make those millions. You could, but you could do better if the issues around your family are settled. So that's why.
So let's just now deep dive into this conversation. I remember I was talking to some people the other day, and they were sharing with me how they were thinking about doing a will, right? And they had received some sort of a checklist from a lawyer. When they looked at it, they were like, I have no money to send to anybody or to transfer to my children.
I really hope that's not my checklist.
And I'm in debt. I mean, really, is this even a conversation I should be having? So I guess the question is, why estate? Why should we be thinking about estate planning in the first place?
It's very important because first and foremost, as you said in the intro, you prevent disputes, which can go long and can be very exhausting and can be very, very costly, actually, in terms if you have a legal dispute around property when you pass on. If your family fights about that, then it could take them years to resolve that. Secondly, as they are fighting, the estate is being wasted, the property is being wasted, because whose is it? It's nobody. So either you waste it or people are grabbing it and taking advantage of the situation. So your hard-earned wealth, it's hard work to build wealth. And then when you're not there, then it could just be wasted. It could go to waste. It may not benefit the people you want it to benefit. You expose it to opportunistic people. So it's very important, apart from now resolving, possible disputes. Also, it saves your wealth, which you have worked very hard for. And then thirdly, it allows you to make the decisions. You're the one who has worked hard, even, of course, with the support of your family. But it keeps you in control of the decision of what happens with your hard-earned wealth. If you don't decide, somebody else will decide for you. And for your family. They'll not know the peculiarities of your pain. They'll not know what you went through to get this wealth. They won't know. They'll just be making decisions based on principles of law, and they're handling 100 other disputes. So as much as you would like for them to understand, this, so-and-so took me to purchase this land, I would not have known about it without them. They won't know that. If you don't plan for it, some detached third party with their own biases. Because remember, the courts are human with their own biases, but guided by the law. But you don't know the experience of the decision maker. So why leave it to a third party
to make that decision for you? But where do you start even? I mean, how do I begin to think through, okay, I need to set aside I need to think through what I want done with my money, with my, things that I want done for my children, and I'm gone, who I want to take over their responsibility if both my husband and I die, or if I'm a single mom. Where do you start?
It's very, it's important to, I guess, say at this point that, a lot of us feel like, what could we possibly be passing on? What could we pass on that maybe we feel like maybe we don't have much wealth, we don't have much. But even if you have a pair of shoes, because a dispute can arise out of that. If Rina, I think, oh wow, I like your shoes, or like I like my sister's shoes. And then when she passes on, somebody else comes and takes them. I'll be wounded for long. Who took the shoes? Was it the neighbor?
Wow.
Was it, jewelry, which may not, it could even be costume jewelry that's not very expensive. Even just things of sentimental value, photographs, just those things. Paintings, things that are of sentimental value. Imagine going to your, some cousin who used to fight with your loved one and finding that she's the one who took a painting that you lovingly gave your, somebody who has passed on. You're like, how on earth did you get this? I mean, like, how was it you who got this? So there are those little things that you need to take care of that may not, we may think you may not have much wealth. And then even outside of wealth, you need to talk about your children. What happens? Who becomes the guardian of your children? Especially, for example, if you're estranged with their mother or their father. Do you want this person who probably abandoned their child to come and say, well, biologically, I'm the one, they're mine. tell your parents, you have something of mine, I'm coming for it. So there are very many issues that arise that maybe not just money, but so we need to think about that. Your circle shares, the money you're putting in your circle, to whom should it go when you pass on, and how should it pass on? Your charmer. And you see, so sometimes you have stuff that you have not thought that you have.
Yeah, you don't think about it as
you don't
wealth.
think, you don't value it, but it's valuable to somebody, and you should be able to make the decision of what happens to it if you pass on. And we will all go that way. I think the reason we are hesitant is because we think we are courting death. Like if you talk about it, then it will come to you. But it will come anyway. You know what I mean?
Yeah.
So it's important to think through some of those things. How do you want to be buried? How do you want to be? And now, increasingly, I'm finding people even want end of life. If I'm very, and this is not really a will issue, because the will only comes into effect when you pass on. But you can do, you can talk to somebody about, if I'm on life support, how long can you possibly keep me on life support? How much, what should my parents, my loved ones spend to keep me alive when there is no more chance of me, recovering? So, some of these conversations.
Yeah, or even like a DNR, what they call a do not resuscitate.
Yes, exactly, yeah. So we need to speak about it, because then your families, you resolve that issue for your family. Then they can deal with other things as opposed to decisions which you yourself could have made.
On their behalf.
On their behalf, you save them the hassle and the stress.
So then where do you start? Is it a list of all the things how?
Yes, and I'm sure the person who was talking about that checklist with the lawyer, I've just thought about my checklist, and maybe I need to review it. Maybe I send it and everybody's like, but think about what's important to you. What would you like to happen when you passed on with your kids? And then think about what you own, because people don't know. If people don't know what you own, what happens to it? It goes to the Unclaimed Financial Assets Authority. So because people hide, you buy this, you hide it, you buy this, you hide it. So at the end of the day, people don't know what you own. So it's important to think, what do I own? What do I have out there? I have a bank account. If your people don't know which is your bank account, they will look through your things, find find ATM cards,
yes,
which pins they don't have, So these are my bank accounts. These are my insurance companies, insurances that I've taken out. This is the pension that I'm entitled to from my employer. Just those things, those general things before you even go into the real estate and the other types of wealth that you have acquired. So it's to have a list of those things, and then to think through what you want. For example, with your kids, how do you want to be buried? Do you want people to wait for other people who are in other countries to come and bury you, or would you rather it be done quickly and people mourn in other ways? So there are those things that you could think about. So it's a list of the assets and other such issues. Who do you want to be the executor? Who do you want to step in and say, okay, she's gone, what shall we do? And who is this person that you trust to take charge?
How many executors can you have?
You can have 2, 3, 4.
Because if one passes on as well,
so there's an alternative. You can have 2, 3, or 4. Yes. So then you can say, in the absence, you can say to 2 people to do jointly. In their absence, the following 2, or in the absence of one of them, the other one will join them. It gives you control, so that it's not somebody, because you know how complicated life is. People may make assumptions, but that's not the person that you want to step in and do and execute your wishes. Yeah. So
there's some of those things that you've said that would kick in after I've died, right? So, and even buried.
Yes.
Remember, so I think we had a chat around that I might say, I want to be buried under XYZ tree on this side of the farm, or I want to be cremated. But by the time they're looking at this will, you've been dead, buried, and now, it's all gone.
So when you do your will, and I encourage you to do your will with a lawyer, because the lawyer knows the little technicalities that you might miss. Ask your lawyer to write to your executor and tell them, they don't have to tell them the details of the will,
Okay.
what's in the will, but they need to tell your executor that so and so has executed a will. Of course, with your permission. Your lawyer can only do this with your permission. So and so has executed a will. This is where the will is going to be stored. She has nominated you to be the executor, and therefore, in the event that she passes on, kindly immediately contact us. And then she wishes for her will to be read. So I have that conversation with clients. When do you want your will to be read? I want to be if somebody says I want my will to be read after I've been buried, then I'll request their permission to tell the executor how they want their body to be disposed of in that letter. So just not all the details, but the key things that need to kick off before the will is read. And then also for somebody to know that they are your executor. They're the executor of your will. Yeah. So it's also a secret.
Yeah.
Yeah.
So I've always wondered, what if where my will is, the firm, it dissolves, or the lawyer decides I want to go into farming and closes shop and
which is
and then
you're constantly playing around with those thoughts of shutting down. But then it's important that you keep a copy of your will for yourself. You can also or give it to somebody you trust to keep a copy for you, or put it in the bank. Banks have custodial services. So ordinarily I say make 2 or 3 copies, and apart from your lawyer, also keep it somewhere else, so that, because even banks can collapse, and then you refer to the lawyer, or something, your executor's house can burn, and then you have, so keep 2 or 3 copies. And it's important to note that the will only kicks in upon your death. So you can still sell the property that you want to sell. You can still deal with it. The effect of the will only kicks in. So somebody can't read your will and say, oh, please transfer this property to me because you've given it to me in the will. Like the prodigal son. It only kicks in upon death. So that's the key thing about a will.
You mentioned to me when we were having a chat that a lot of times people ignore the process of putting together a will because it can be contested anyway.
Yes.
So what's the point? Please speak to that. Like, is it necessary anyway? It's going to be contested anyway. It's, so are there certain situations when a will is contested?
A will can be contested, for example, if it's not properly done legally. So, for example, if it's a written will, whether it's so there are 2 types of will. There are written wills and oral wills. I won't go so much into oral wills, because if you do an oral will, you have to die within 3 months. So it is only valid for 3 months.
It's only valid for 3 months?
It's only valid for 3 months.
Oh, wow.
Unless you're in the army and you die at war, or you're in the Marines, then you had made your oral will at the, before you left. But everybody else, if you do an oral will, it's only valid for the next 3 months. So if you did an oral will in March, fearing COVID, it's no longer valid now.
Excuse me.
And then for it to be valid also, there has to be 2 competent and independent witnesses who hear you making the will, and they are not beneficiaries of the will. So there's, it's a very elaborate. There are technicalities that would, will render it valid or invalid. So if you made an oral will and there's only 1 witness, that's not a will. So this is how wills are now invalidated and challenged.
Yes.
Or if it's a written will. Also, a written will requires to be witnessed by 2 witnesses who are independent, objective witnesses who are not beneficiaries, who are not beneficiaries of the will, And then they need to be people of sound mind. You yourself need to be of sound mind. So one of the things that is that people raise issues, they say, oh, our mother was not of sound mind, or our father was not of sound mind when they made this will, and you look at the date of the will. So those are some of the things that arise. But if everybody knows that you are of sound mind at the time you are making the will, then there's nothing to be, there's nothing to challenge. But what I want to say is that wills can be challenged, but whether the challenge stands or not is another thing altogether. Because there are people who are quarrelsome and litigious and always want to fight and want to never give in without a fight. But the question is, will they stand? So will that challenge stand? You could go to court and challenge it, but will it stand? So there are things that you can do to make sure that it is not challenged. So if you did it and you're of sound mind, it was witnessed by 2 witnesses, you signed in their presence and they also signed in your presence, then it's highly unlikely. Those are the two witnesses who say, well, she was working at Central Bank. She kept on, I mean, she left the office of the lawyer and went back to work. How can you say she was not of sound mind? You see? So those are some of the things that people challenge. Oh, she was not of sound mind. Or there were not two witnesses. Or sometimes people challenge it that it was forged. But it's the person claiming forgery who must prove that there was forgery, number one. Then another, and the last one that I'll mention that it can be challenged is when you say that the person was coerced. It was not willing. They were pushed and harassed into writing this will and to putting this content in the will, and it is the person making that claim who has to prove it. So there would be circumstances that show that is if you have 3 kids and one of your children is the witnesses and they get everything under the will. You see, then so there are some of those things, but they are very clear in law and people can challenge. The question is whether the challenge will stand. So people are afraid, will it be challenged? Will it be challenged does not mean the challenge will carry the day. It could be challenged and the challenge fails. So there's still something to be said for doing it. Yeah, because then people know what your wishes were. And I find that once people know your wishes, I mean, sometimes the courts will say, is this fair? And then even the person to whom it looks like it was unfair will say, but those were her wishes. Or those were his wishes.
Whether it looks fair or not.
Whether it looks fair or not, those were there. I've accepted that was my dad's wish, or that was my mom's wish, or that was my auntie. We've accepted that was her wish, and that just resolves the dispute, because that was her wish. Yeah. But if there is even no indication at all of what should happen, it's up for grabs for everyone to claim, and then it's a mess.
And so even if you have children. Or a wife that people don't know about.
And you don't have a will. So you see, that's another thing. In your will, you need to state who are your beneficiaries. My wife is so-and-so. My husband is so-and-so. My children are so-and-so and so-and-so. So you put them out. And then if the other people come and claim, they'll be claiming us. They will be having to prove that they are your dependents, number one. Number two, they would have to if they're coming to claim first, not only will they have to prove, but also you could actually mention, because remember it will kick in when you're gone. So it would be important to mention if you have kids out of wedlock, or if you have somebody who could legally claim to be a wife, you could put it in there and say, but I have provided for them in the following way. I have bought them property here. I have settled them with this amount of money. So please don't come and disrupt that which I tried to keep, safeguarded for so long. So it would be good to say, I have to, because this won't be read until after you're gone. So you could say, I had a child out of wedlock with so-and-so, but I have provided for this child in this way. So therefore, this is why I have not provided for them in the will.
Okay.
Or I had a relationship with so-and-so, she was not a wife. Because you see, our law is so interesting. It has a very interesting clause that we are trying to change, but it's problematic.
What's that?
That if you don't write a will, and your estate is going to be divided according to the laws of intestacy, for example, or even if you have a will and you have left out certain people, a wife for purposes of succession is different from a wife in life. So like if you're still alive, there are people who cannot claim to be your wives. But once you're dead, the Law of Succession Act opens it up, which is why we always see multiple wives against the background of Lee Funeral Home.
What?
So we didn't know this person had wives, but these people were not really wives.
They were
as long as they were alive, as long as the person is alive, they are not wives. But it's a misnomer, it's a mess in our law, which was introduced by, I would say, heavily male parliament in the 80s. But yeah, so the wives, for purposes of succession, are very different from, so, women are, you stay, you're the one with the certificate, but the law, once he dies, actually, the law allows other wives to check in.
That's insane.
So it's a very strange thing in our law, which is why it's important to mention
Oh
it
my God.
in your will and say, my wife is so and so. So and so I had a relationship with, but she's not a wife. She does not, qualify to be a wife. Because then, anybody can come in and claim to be your wife.
Okay, let's put bills aside for a second. What else?
You can
I
do other things.
Okay.
Okay. So people are afraid of wills, and and you're you kind of get what can I say, nervous around wills. You can even at the point of acquiring property, you can think about what you intend to happen with this property when you're gone. If the Bible says, teach us to number our days. We all know that we are going. We all know how this story will end. I always laugh when I hear somebody say that, because I'm like, yeah, don't remind me. But we all know how this story will end. So even when you're purchasing, you can decide how you want it you can do it with a numbering of your days mindset, where you think, if I passed on, what would I want to happen to this property? And so at the point of acquisition, so for example, if it is land, at the point of acquisition, you can decide that I want to own this property jointly with somebody. And when you put in fact, when you look at the transfer of land, it already gives you that opportunity. But it's usually the standard transfer of land under the Land Registration Act. But usually it looks like it's in small print.
Okay.
But there is a significant clause there that when you're more than one purchaser, it allows you to say how you want it to be owned, how you're going to hold it. Are you going to hold it as in common or jointly? So there are different ways. Common or jointly, yeah. As proprietors in common or as joint proprietors.
So that's in the sale agreement? Or
no, that's in the transfer. You see, you first do a sale agreement, and then the transfer, which is the actual document that you take to the lands office
to get the title.
For the title to be issued in your name
as
the purchaser. So at that point of purchase, you have an opportunity, if you're purchasing it with somebody else, or you have an opportunity to add somebody else and say how you're going to own it. So you can say it will be owned jointly. When you say it will be owned jointly, Rina, if you and I go and register property today jointly in our names, it means if I pass on, it becomes yours absolutely.
So you cannot say in your will that I bought this piece of property with Rina, my half goes to my child so-and-so and this other child.
Not if it's jointly owned. If you say jointly owned, it means that you have to, it's not subject to the succession.
It will be mine 100%.
It will be yours 100%. The only thing, Irina, you need to do is ask Muteru. My husband is called Muteru for the title deed. If he's the one who has it, if I had it, and get a copy of the original and copy of my death certificate. Take it to Land's office, and it's transferred to your name. So that's joint ownership. In fact, in 2012, when we changed our laws based on our aspirations under the new constitution, we were going to own land in a way that takes care of equity and equality, and we want to protect people who have been disadvantaged in the past. In 2012, the Land Registration Act said that you could not own land jointly unless your spouses. Okay. In 2016, it was sneakily changed, and now you can own land jointly with
anybody.
Yeah, with other people. So please, if you have somebody on the side, register property jointly with them, and then they don't have to come and harass your wife and cause her pain when you're gone. So she can have it.
And if you don't want that, so if I want a situation so that if I died and you are the one taking 100%, really, I was investing for my family, my children.
Then that way you register it in common. As proprietors in common. So that form, it's a little part of the form, but then you cross out the joint and allow it to be registered in common. And this is what people should do even with land that you're buying together with chamas. For example, I see people in a chama, 3, 4, 5 people, and you put
people, and you're 50 people in the chama.
So there are some of the things like, for chamas there is a way you can do it, but for a property that you're buying, we are buying you and I, Rina, we can say in common, in equal shares, in common 70-30, in common, to this proportion, if we say that, we say in common in that way, it means when I pass on, my share, my 50%, 60% will go to my estate. So it will either be the subject of my will or the subject of intestacy, but you keep your share.
So in that case, let's assume the asset belonged to 10 others and you are holding it jointly with the treasurer.
If you're a certain amount of people, I would say register a company, register an entity, so that it says the 2 or 3 people holding are holding in trust for the members of such and such companies, such and such, such and such business, partnership, that sort of thing.
Or just buy the asset in the name of the business.
Or just buy, you see, unless you're a company, it will be difficult because there are some entities that legally cannot own property in their own name, so they would have to be held in trust by individuals. Yeah.
Okay, so that makes sense. But then, have you ever found that perhaps, so if it's a husband and wife situation, so here we are owning jointly, but it's a husband and wife situation. Okay, I secretly fear. Okay, so I love my husband to bits, but let's just say I died, right? And we were having this conversation the other day with him. I died and then he remarries, right? So we own property jointly. And now mama comes. And now what happens to my children?
Yeah.
Right? Because now property transfers to him and now he has other dependents. And I really wanted to be able to secure the future for my children. So in that situation, I'm assuming just from what you've said, then I would own it jointly but in common, right? Where each owns 50-50.
Yeah, you can do in common.
So that then my 50 goes to my state. However, should it be, but then if he doesn't end up in that situation, then I limit his ability to own that property and help my children anyway. Am I right? Or
okay, I hear you, and your concern. It's so common with wives. It's very, very interesting. I don't know. I think wives think he'll remarry. Like he'll remarry. And I think wives don't think I would remarry. I don't know. It's just the way it's set up, or I don't know if marriage is hard on us women, but anyway,
if
that's
you have
a conversation.
3 children, surely who's marrying you? When you're over 50?
You'd be surprised looking like you do. But anyway, so I find that it's very common. You see, it's a very interesting conversation. So for the woman on the ground whose husband would ordinarily put property in their name, in his own name, because we have this culture, the wife is, the property, the men are property holders. So he's holding it for the family, for all of us. So he holds it in his name. I'm his wife. In fact, I'm Mrs. So-and-so. The children are his. So he's the overall holder of our things. So for the woman whose husband is most likely to just put property in his name and she should know she's sorted because she's a wife, joint ownership looks so attractive. If he puts my name in there, it looks very, 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 very attractive. So you are happy to say it's okay. Let me just be joint owner. But I'm seeing now a new level where you think, well, if we are joint owners and I die and he remarries, just the question you're asking, he takes the death certificate, the property turns into his name, and then he can do whatever he wants with it. So I see moms with a lot of that concern, and then so you could still put it in common, so that 50% your share, you can determine, you can put it in the will. If you put it in the will, it will go to your kids, or he'll hold it in trust for your kids. So there are certain things he cannot do with it. And then the other 50% is his to do whatever as he wishes with. So, whatever he wants. So in that way, your kids are safeguarded. Yeah, so you can do it joint or you can do it in common. Yeah. But if you're married and you don't state whether it's joint or common, the assumption is that it's joint. Yeah. So you'd have to be very specific and say that you're holding it in common, so that if you pass on, 50% then is his to do whatever with, but the other 50% has to pass to your beneficiaries.
Yeah. So if I'm holding it jointly with my sister and it's a money market fund account, what document would then say that I'm holding it in common?
Okay, you see, this is basically for real estate.
Okay, that's for real estate.
For real estate. But yeah, you can, in your money market fund, you designate.
But you designate a beneficiary.
You designate a beneficiary. Actually, but if you have it jointly, yeah.
For a second, yeah. So there's certain assets where you designate a beneficiary, and whether or not there's a will, that beneficiary gets the money. But there's other instances where, yes, there's a beneficiary, but nobody cares what you've written at the beneficiary, next of kin. No one cares. It's what does the will say. Everything goes to the estate, irrespective of what is written. So please share with us, what are those assets or things that you can own, belongings, that then go to a beneficiary. And so you have to make sure you're completely up to date, like literally annually, on who that beneficiary is. And those others that you just have to, you can't do anything about.
Yeah, it's very important. First, next of kin, you say next of kin, it's a very common term. People say next of kin, I'm his next of kin, I'm her next of kin. Next of kin is not really a beneficiary. First, next of kin is not a legal term, so you will never, you'll never hear who was there. Next of kin is the person we will contact.
If there's a problem.
If there's a problem, that's who next of kin is. They are not usually the beneficiary. So you should designate a beneficiary for certain things. And these are things which pass through a process called nomination. And what that is that it doesn't have to go into succession, it doesn't have to go into your will, it doesn't have to go to court. Because what we need to know is that whether you write a will or you don't write a will, there is a legal process. There is a legal court process, not a dispute. You see, if there is a will and it's not being disputed, it's not a dispute. Even in where there is no will, you can go and do intestate succession without a dispute. You agree and it goes without a dispute. But there has to be a court process anyway.
What's intestate succession?
Intestate succession is when you don't have a will.
Okay.
Okay. So there's a court process. But then there are things which are the subject of nomination which don't have to go through a court process. Insurance policies. Take out an insurance policy or a life, I think especially all insurance policies, you nominate a beneficiary. So that's not a court process. Once the person passes on, you just need to show I'm the beneficiary. Now, I don't know if we've become very litigious, but I'm starting to see insurance companies saying no. If there's a beneficiary and there's no contest, if 2-3 beneficiaries show up, they tell you go to court. Okay. So poor courts are bogged down. The issue should be nomination. The legal issue is nomination. Who did the person nominate?
Yes.
So if you nominate somebody to be the beneficiary of your insurance policy, please make sure that you update it often. Tell the insurance company if you're changing, or at the point of buying it, this is what we were talking about earlier. At the point of buying it, determine that I'm buying this so that if I pass on, it benefits so and so. And I hear people saying, oh, then the person will kill you, etc. But, the human nature, there are some things you can't, there are some things you can't control. So to save the dispute, so insurance policies are the subject of nomination. SACCO dues. Your SACCO dues don't have to be the subject of a court case. Just update your SACCO yearly or every 2 years on who you want to be your beneficiary. So that if you have 2, 3, 4 million in the SACCO, why should you wait for your spouse to go to court to be able to feed your children? It should be the subject of nomination. They go, they show I'm so and so named as beneficiary, and the SACCO releases those funds. In fact, SACCOs release funds even if you had a loan, because the loan is secured.
Oh, yeah, because you take
the loan is insured. Yes. The loan is insured. So if you've saved 3 million and you've taken a loan of 9 million and you pass on, your family still needs to take. Why put them through a court process? Let these funds be available.
Even I think you also mentioned pensions.
And pension schemes. But I think also because our family, we are so fluid with our families that I'm finding that even pension schemes are now becoming a state. I think everybody should just become a lawyer, because there's so much work to be paid, because I found pensions are also the subject of nomination, if you think about it. But so once you would tell your employer the nominee for the beneficiary should be so and so, it should be automatic. They shouldn't have to go through a court process to get the benefits of your pension. It should be automatic. But because of the way we are set up, I think we set up the way we run things. I'm finding that actually now even employers are saying no. Go, if so, because you've all rushed. As the widow is mourning, the brother of the deceased has rushed to the employer and said, I'm the beneficiary and this is not a wife. We should stop it. These are things we should stop. So now, if the brother has come and the employer knows the wife, then they start to think, was she really a wife? And then they tell you, go to court for the court to determine that. I mean, guys, give the courts a break. Please let the courts determine real disputes because they are overwhelmed. You know, really, there are some disputes that we should resolve. I mean, luckily, we are moving into alternative justice systems, and there is mediation, and you can try and resolve that.
And arbitration.
Yeah, arbitration is expensive, you know, because, you know, an arbitrator is a private court. Just, you know, well, let me not say too much because I might go into arbitration. I might want to go into arbitration.
Okay,
but for everyday Kenyans, you know, I think spare the courts.
Yeah.
There's really backlog. There are things that we can solve ourselves. And that's one of the things. With nomination, it doesn't have to go through any court process. Because even just the succession process involves going to the chief, getting a chief's letter, waiting for gazettement, waiting for a date in court. Save your family all that, and just, you know, nominate beneficiaries for insurance policies.
Yeah.
You know, do joint ownership in common. There are other things you could do that take you out of the court process.
Okay. We have many questions.
Oh, really? Okay.
Yeah, so I don't want to miss out on them. So let me just go there now. So thank you, Betty, for watching. She says, good morning, ladies, from YouTube.
Okay.
Aruna says, we've come a long way with this topic. Well done. Harold Muganda, this is very insightful. Lily says, hi, ladies. How do you go about writing up a will when you have a child with special needs and will probably be dependent? Yeah, it's a good question. Yeah, how do you go about writing up a will when you have a child with special needs and will probably be dependent on your care even after death? Is there a special format for that kind of will? Are there ways to start a trust for the child, even modest?
Yes.
It's a great question.
Yeah, there are ways to start. The first thing you would do is to nominate a guardian. A guardian? Yes. A guardian of one, the child, the physical care of the child. If you passed on, who would take that up? Number two.
Wait, but even with the guardian, you don't just nominate, you have to talk to them and tell them.
You have to talk to, of course, yes, of course, you have to talk to them. It has to be somebody you trust. It has to be somebody who is invested in your child. And then there's also guardian of the property of the child, so that you know I'm leaving X, Y, Z amount in a bank or in a pension fund or in a SACCO for this child, and the person who is going to be the trustee and the guardian of this property is so and so. It could be the same person who's a physical guardian. You could actually talk to two people to help each other, and so this guardian will have a responsibility and a trust to make sure that the funds are used for the benefit of the child. So it could even be something simple, rental property, you know, where you say this property upon my death will be passed on to so and so to hold in trust, and all the rental income will be used for the benefit of my child.
How do you ensure that that is executed so that this person who's a beneficiary doesn't go ahead and just do their own thing?
First, by choosing, of course, a reliable person, and also by making sure there are 2 or 3 people so that they hold each other accountable. So we all know this is what she intended for the child, and we are all in this together to safeguard the child so that they hold each other accountable.
Yeah. Okay. And so that would all be held in a will?
You can. It would be best to put it in the will, because if you don't put it down somewhere, either put it in a will, or if you take out an insurance. In fact, even if you take out an insurance policy, because sometimes we take out insurance policies and nobody knows. Yeah. So list them in your will. They will not be the subject of a court process, but list them in your will so that your executor knows that there is money in account with insurance policy number this, or there is money with SACCO this, or there is money with Achama. There's $1 million that Achama is holding that will benefit the child. So put it down, let it be put down in writing, so that people know. Even if it doesn't have to go through a court process, then people know it exists, so that you're not scrambling and wondering, what did she leave? Because, you know, death comes so unceremoniously.
Yeah, yeah. Okay, so, and a trust?
Yes,
that work for this situation?
Yeah, that would work, where you set up maybe, you put the properties to be held in trust for the child, or you set up like 2 or 3 people as trustees to, you can do a trust company. The thing with companies is that the requirements are becoming more and more stringent, and changes are happening every day in terms of what you need to do, but you can actually put things in trusts.
But I also
so somebody
find it's expensive, because I'm thinking about, sorry to interrupt you.
No worries.
But I'm thinking about some of the, famous situations and cases we've seen in court where there was a trust, and he did everything possible to ensure that his children were taken care of, and put trustees to then make decisions, because he figured my kids might fight. So let me get 3 trustees. But these trustees have set up companies or made decisions that were perhaps expensive for the estate to run, and not in the best interest. So so clearly the will has to...
I think, I mean, it would be good to put it down, but also what I wish we would do is I think it goes to also the way we run our families. We really, really need to think about safeguarding the family so that we reduce disputes. If there were no disputes, these things would run smoothly. So I think for every big dispute that you see, there are other 10 or 20 families running things without a fight. So one way is to set it up in a way that there will be no fights. But if you know that they will fight, then have specific people hold the property in trust and run it in a way that you'll be able to benefit the family. But the problem is now families fighting the trustees. You see, I guess there is no 100% answer. I think my view is that degrees of peace. To what degree, with your family, it will never be 100%, but at least you can set it up so that there is 70% peace and only about 30% of a dispute, as opposed to a full-blown, all, gloves off sort of fight.
Okay, so let me go to the questions, and thank you so much everybody for your comments. Most people are saying very informative, very informative. Leah Kiguatha is one of the best family lawyers in the country. Very informative session. That's from Orioki Kinoti.
Thank you.
Eye-opening. Joram says maybe we get less kids. So here's a question. Linda says, great conversations, ladies. If I already have a title with my spouse, so I'm guessing it's owned jointly, how can I check if it's joint or in common? And if it's joint, can I change?
Yes, you can change.
Okay, first question is, how can you check to find out whether it's owned?
You can do a search. Take a copy of, first, just from looking at the copy of the title, you will be able to tell whether...
Okay, so it says...
Yeah, it says, as joint owners, or as joint proprietors, or it says in common in equal shares, or in common in the following ratio. So it would say on the title. If you have doubts, you can do a search, because when you do a search, the register may tell you a little bit more. If you're married, the presumption, unless you say in common, the presumption is that it's joint. And then there is also a process called transfer of undivided share. So you can actually do a transfer where you now hold it in common. So that's possible, yeah. And because if you're still married, there'll be no stamp duty on that.
Oh, there won't be any stamp duty. So it's just filling out forms and sending them to where? The lands office?
Sending them to the lands office and having the transfer done.
Do they need to do it through a lawyer?
Of course, I would say yes to that question, Rina. But they don't have to. It's not obligatory. It's
just simpler.
It's easier.
It's easier.
Yeah, it's easier because we do these things. We can do these things with our eyes sort of closed, not 100% closed. But it's easier.
Wow. Okay. So I want to just go back here to the questions. So I think what I want us to do, because I'm just looking at the time, we have like 10 minutes. I want us in summary to just say, what are the key takeouts?
Okay.
Because this is a big subject. And, so first of all, you have men out there who are listening to this and they're just like, Ati, I tell them what? I own what? I remember there's a friend of mine who is a banker. And in this particular branch, it's downtown. And you know, they have these old men coming to them.
Wealthy billionaires.
But they look at them with a funny hat, with a sweater that has been worn for 65 years.
And you must never tell your wife must never know.
Never. For the wife has no idea this guy has 150 million cash sitting in the bank account. Now, what would you tell that gentleman?
You know, Rina, we were having this conversation earlier where I was saying, I mean, I've just thought about how you need to, you need your spouse or some of your older children to be joint, to be able to be signatories of that account or to have the PIN to that account for your ATM. Because if they don't, you pass on, and that's the end of that. If you're the only one who can access that account, people will be scrambling to feed the mourners who come for your funeral.
There's so much money.
Your landlord could lock your house, or people could come after you. You know, I can't even imagine what stress you put your spouse and your children through. And there's 150 million benefiting a bank. Why? Why would you want to benefit a bank, a stranger, instead of the people who loved you, the people you go home to every day? I think we really need to rethink these things. Because now imagine, there's 150 million. There's no food for the mourners. There is no...
Forget the mourners. The
not
children.
Even no, the children. There's no... You see, the children, I imagine, will be fed by the surviving parent. But I'm imagining you having to think. Yeah. And then also school fees, just the basics, medical, school, food, clothing, shelter. Yeah. Then a bank has the money. Why? Like, how does that even make sense? Yeah.
So educate your family, basically.
Educate your family, let them know. Yeah, talk openly. Try to safeguard whatever you want to safeguard in ways that you can safeguard it. Yes. But the liquid cash, because it will be a year before your spouse can access that money.
At least.
And it will mean her going to a lawyer, paying legal fees, starting a succession process, asking the court for permission to draw just school fees, going with every term or every year with a breakdown of fees. I need fees for this child. Why? Just, I think organize yourself. Let's prioritize our families. Our families are important. Yeah. Because I don't understand why you would want the bank. The bank will keep the money. They'll be liquid. And they'll sell. Wait for the grant.
I saw a number on Kenya Moja that's related to that. That I was just like, for my heart dropped for a
yes.
second. Because they said it's estimated over 200 billion.
Can you imagine?
Kenya shillings is sitting with financial institutions that belongs to families in this country.
Yeah.
That's a heck of a lot of money.
And those are people suffering. Those are children not going to school. Those are children not eating. Those are people not being clothed. Those are spouses having medical bills they cannot pay because you'd rather the bank benefit.
Okay, the second one. The second one, in my view, as a takeout, is what I heard you say in terms of beneficiaries. Another story I had a lawyer say was that, so this guy got a job. And he was working, he was at 24, grew older, married, children, dies at almost 50, but forgot to change the beneficiary from his mother, right? He has children and a wife, but he just forgot. And 10 million shillings gets released to the beneficiary of this insurance company. And guess what? Mother and wife cannot see eye to eye. In fact, mother hates wife. So what happens? Children, mother, no money. Struggling, and the mother of this man is for I don't care. He was my son, the money belongs to me.
This is what my son left me.
So please, based on what you said, you need to update, right?
Update those records, update with your insurance, update with your SACCO, and update with your employer where it's a subject of nomination. Please update. Even your will, don't let it stay more than 5 years. Before you update it, do a codicil, updating it with new property, or changing it completely and doing a new will. I would say every 3 to 5 years, just change it. Although wills they are ambulatory. So if I say all my cars, even if at the point I was doing the will, the cars, I didn't have this car, all my cars will go to so and so. The cars that you have at the point of your death will go to the person, even if you didn't have those cars at the time of the writing the will. Wills are ambulatory. But it's good too, because life is dynamic and our families are dynamic. So it is important that you update regularly so that it doesn't go with the old records and your life has changed. Yeah. And then if you're that mother, come on. These are your grandchildren.
know.
You don't have to give.
Actually,
I mean,
yeah.
you still have, even if your son left it to you, you can still give it to the children of the deceased. They're your grandchildren. So also, you see, also an attitude, a heart and mind process needs to happen with us.
So it's just just a comment around. Yeah, gladly tuned in. Very insightful information. Thank you, Leah and Rina. So those are two great takeouts. What else would you say that anybody who's listening to this must remember to do?
I think in summary, one, keep calm and write your will. Yeah. It's important that you write your will. It's important that you work with a lawyer so that you work out the kinks and the technicalities that will make sure it's not challenged. And then also, if it's being challenged and the challenge succeeding are two different things. So don't be afraid because it can be challenged. It can be challenged and the challenge can fail and collapse. So you can't stop somebody who wants to challenge it, but you can work in a way that any challenge will be, that any challenge will collapse and your will carry the day. That's number one. Number two, you can go beyond the will. The way you own property to begin with, you can make sure that it bypasses the succession process by registering it as joint ownership or as ownership or as to be owned in common, so that a share bypasses the will process and the other share goes to the person with whom you own in common. And then you can also do things that just are processes of nomination. Put your money, get out insurance policies, the money in the circle, put it in your will nevertheless so that people know it exists. Yeah. So that people know you have shares with this circle, you have shares with this chama, you have this insurance policy. Put it in so that people know. But it is the subject of nomination and there will be no court process required to have the property pass in a way that safeguards your family.
Yeah, I think that's the first place to start, because I'm telling you, people don't know what they own. I used to have shares. I don't even know which company I bought them through or what they are.
Keep good records.
I used to have, in fact, I bought land. I don't even know where it is. Like, that's the first place to start. Keep good records.
And who's going to benefit if you pass on? A quarter.
Imagine.
Or the county government will take it back. Instead of your family, fine, our families are not perfect, but they are who we have. So let's take care of them. Let's prioritize them. Third parties, banks, insurance companies, unclaimed financial assets authority, government. Why would you give these other people your hard-earned wealth? Safeguard your family. Family is good. Keep it close if you can. Minimize disputes and let's take care of them. Don't let third parties benefit from your sweat. Let the people who are close to you be the ones to benefit. Also give to causes. Your will allows you to give to causes outside of family. If you don't have a will, only your family will benefit. But if you have a will, you can give it to other causes. You can give money to whichever causes you favor. And that way your hard-earned, you have a say in what happens with your hard-earned income and wealth.
Fantastic. So how can people get in touch with Leah?
My website is kiguathalegal.com, so you can look me up.
Okay.
And we can have, and I'm on LinkedIn, I'm on Facebook, Kiguatha Law. So we can have these conversations.
Yeah, actually, if you have more questions and just want more information, I've seen several articles that Leah has written and posted on LinkedIn, which actually that's how we ended up here, because I thought they were really, really, really helpful. So just follow her on LinkedIn, and if you have any questions, feel free to get in touch with her through her LinkedIn profile or her website, as she has mentioned. Thank you so much, Leah.
Thanks, Rina. This was a fun conversation.
I know, so interesting. I've learned many things. I'm going today. There are things I need to do. I have takeouts for myself that I need to make sure that I sort out. Thank you for coming, and thank you so much, guys, for listening, for watching. Please share these videos with guys who are your friends, relatives. Share it on your profile, because people need to get to know this information. In the beginning, I shared a statistic that out of the cases, the succession cases that end up in court in Kenya, 10% of them have no wills. So there's a lot of,
only 10% have wills.
Oh, that's right. Only 10%
for
have
Kenyans of
wills.
African descent. Yeah.
For Kenyans of African descent. But when you look at Europeans, it's 90% have wills. Asians is about 75%. So we have a problem as Africans because we don't really, it's like it's taboo.
But I think also the reason is, if we have just 1 minute,
Sure,
I'd
go
like
ahead.
to say is, I guess, okay, it's because we owned things communally, traditionally. So it sort of would go, you knew what would happen. But now we've moved into, decades and decades of individual ownership. But I think we don't want to make that decision, but we must.
We just must.
Yeah.
We must. Alrighty, have a fantastic day ahead and a wonderful weekend, and God bless you so much. Take care.